CJ Colley had his artwork stolen by a company with more than 10 million users and wasn't compensated for this infringement. Instead, they offered to pay him to advertise their product. Can CJ sue? In early 2008, street artist Shepard Fairey designed this poster for the Obama administration that closely resembled this image taken by AP photographer Manny Garcia in April of 2006. Here are the two side by side. There was a subsequent lawsuit in February of 2009 where AP stated that the photo required permission to use and that the permission was never granted. Barry then filed a lawsuit to protect himself from copyright infringement penalties, and the judge stated that AP would win the case and that they should settle out of court. Ferry later admitted to using the photo but destroyed evidence that he did and was subsequently penalized by the courts. So, how does this relate back to CJ and Kittl? Well, let's look at this comparison. The example was used in marketing material to promote the app Kittl, an AI platform that, quote,
empowers creators, designers, and businesses to produce standout branding and product visuals faster than ever.
here's what they used in 2026, and here's what CJ made in 2025. The cat is the same, the fire hydrant is the same, and even the P is the same. The only thing that was changed by Kittl was the pose. Unlike the Obama poster, this marketing material directly used assets straight from CJ. It even kept his brand tagline. I highly recommend visiting CJ's page to see and hear his story and how Kittl didn't contact him for permission to use the artwork. According to his post, he was contacted by a senior member of Kittl's team that apologized for the infringement. But I don't buy the fact that they were sorry about it. As commenters pointed out, and what I personally believe is that they weren't sorry that it happened, they were upset that they were caught. CJ, being the great guy that he is, does not seem to be moving forward legally. He is instead selling a shirt and is using that money to mentor individuals who aim to start their own creative studios. Awesome. But what if he did move forward with a lawyer? Well, here's what I believe can happen. Please take this next part with a grain of salt. I am not a lawyer. Can CJ go forward legally? The short answer is most likely. The long answer is that according to German copyright law, since Kittl is based out of Berlin, any work created by someone is automatically copyrighted. It does not require a filing or anything. In section 20B, it states,
where the author has granted the right of retransmission to a broadcasting organization or to the producer of an audio recording or film, the retransmission service is nevertheless required to pay the author equitable remuneration for such transmission.
So CJ has a case that they retransmitted his artwork without paying him. It's up to the court to determine if Kittl's adaptation of his work is fair use. But German fair use is similar but not the same as American fair use. In section 23, they state,
adaptations or other transformations of a work, including in particular of a melody, may be published or exploited only with the author's consent. If the newly created work maintains sufficient distance to the work used, this does not constitute adaptation or transformation within the meaning of sentence 1.
This seems like there is not enough distance needed to detach their work from CJ's work. That is ultimately up to the courts, though. And to me, it looks like CJ is not going to take it to court. The reason I am making this video, though, is to highlight how AI companies can and will steal your artwork if they believe you will not fight back. Had CJ been a small creator like myself, I may not have gotten notified that they use my work. If you enjoyed this video, please consider liking and subscribing. It would help out immensely, and any support is greatly appreciated.